everybody.
Mr. Miller, correct?
Yes.
All right, so you were told that you were gonna come in 15 minutes, so 10:30. So Ms. Solomon stepped off for 2 minutes, but we're gonna call her and tell her she has to log back on. So I would like you to just stay where you are, okay, sir?
Okay.
All right, we'll be right with you.
Okay. I won't go anywhere.
22001080, the people of the state of Michigan versus Michael Andres.
Good morning, Your Honor. Lord Camacho, on behalf of the people.
Good morning, Your Honor. John Taylor on behalf of Michael Andres. Please state your name. Michael Andres.
Mr. Andres, are you still using an address on Turner Street in Detroit?
Yes.
Today is the date and time that's been set for sentencing for Mr. Andres. He was screened by the probation. Actually, he wasn't. I'm sorry, I forgot what happened here. Did you get the note?
I did, Your Honor.
What's going on?
Discussion with him. He appears to have forgotten. Ask her to do.
So you were given a date to appear for your interview on October 1st of 2024. Do you recall that?
Yes.
Okay. And not only did you not appear on that date, but the email that you provided to the court, as well as the voicemail that was obtained from your cell phone number, none of them were able to get you in touch with the court to even make an attempt to reschedule the PSI. So what is going on with the phone number that we have for you, and what email are you going to respond to?
I have an email.
So I'm not sure which one they used, but we didn't have one attached to the file here. I don't know if you've updated that at the clerk's office. Just give me a minute here.
Your Honor, he did change his phone number. I admonished him for not letting me know that too. The 517.
So can I just tell you this? So probation, it's almost a guarantee with a domestic violence case when I see you. It just depends on what else I learn about you. If it's something where I would also consider jail time, or I would make a longer term of probation. But if you can't provide just basic contact information so that you can keep in contact with the probation department, it becomes really difficult to even consider a term of probation in lieu of jail. Do you understand that?
Yes.
So this is kind of a test run to see what would happen if we decided to put you on probation. And right now I have some concerns. So what is the phone number that you are using? Okay, and what is the email, sir? And you're still using this exact same address, right?
Yes.
Okay. So I am going to give you one opportunity to go back out and get another date. And they will expect to see you on that date. They're not going to give you any accommodation if you're late or if you miss. If you do that again, we'll just set it for a show cause. So the next time you see me, we'll have to talk about why you are potentially not in compliance with the court's orders. And the only other alternative I would have would just be to revoke your bond so we can actually get you screened. So you have to appear for the date that you're going to get today before you leave. Do you understand that?
Yes.
All right, head up to the front counter. They'll call you up momentarily and try to get that rescheduled for you.
All right.
Thank you.
Thank you.
Hardman, correct?
Yes.
Okay. Are you ready for this case?
The judge, I met with him in lockup. I went over everything with him. He wished to have a trial. He just indicated to me that he does not want a trial.
Okay, so would you like us to pass the matter so you can talk to him briefly?
But I inquired with the people, is he eligible for 7694A status?
We'll have to talk.
Okay.
So that's something too, she may have to check with the victim, but we can pass this and bring it back in just a few minutes if that's okay.
Sure.
Can you
Do you have his lien record?
What?
Do you have his lien record, Judge? Do you know if he has any assaultive crimes on his record? Just before we have a conversation about it. I read the police report. The police report's indicating no, but.
So, other things that would not be considered because they were dismissed. But there is one that I have that I don't know. I think it was maybe scheduled for trial. I don't know if it proceeded to trial. And the defendant was found guilty in Novi, or if the trial was avoided because he decided to take a plea. I don't know, but it does look like there may be something there.
Okay,
Okay,
can we, obviously he's changed his mind, can we have to submit that?
of course you can. So we'll bring you back down in a few moments to go on the record, and Mr. West, as soon as he finishes up what he has in the courtroom, he'll come down to see you, okay? Thank you. This is 24002566. The people of the state of Michigan versus Lorenzo Hardnett.
Good morning, Your Honor. Laura Camacho on behalf of the people.
Josh West on behalf of the defendant.
Could you state your name?
Yes, my name is Lorenzo Harnett.
Sir, are you still using an address on Old Homestead in Harper Woods?
Yes,
Today is the date and time that was set for a second retrial. It appears that you've had an opportunity to discuss your case with your attorney, and there may be a decision to proceed today with a plea. What would you like to place on the record?
He will be pleading guilty as charged. I did speak with the prosecutor, and indeed, he's not eligible for the 7694A status. There was a domestic violence that happened after this one that he's already pled to, but this one, as I understand it, is first in time. Right?
That is my understanding, yes.
So nonetheless, he's not eligible, so he'll be pleading guilty anyways.
Okay, sir, can I have you please raise your right hand? Or the right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
yes, ma'am.
Thank you. You'll just have to speak up for me really clearly, so
Yes, ma'am.
thank you. Did you have an opportunity to discuss your case with your attorney today?
Yes, ma'am.
And did the two of you go over this form known as People's Exhibit 1?
Yes, ma'am.
And did he explain to you all of the rights that you have coming to court as a defendant in a criminal case?
Yes, ma'am.
After you discussed this document and reviewed each of your rights, did you sign the sheet toward the bottom of the second page?
Yes, ma'am.
Do you understand that the maximum penalty for this offense, it could be up to 93 days in the Oakland County Jail and or a fine of up to $500 plus court costs?
Yes, ma'am.
Do you understand that if you're on probation or parole, depending on the timing of the offenses, this plea could negatively impact your status?
Yes, ma'am.
Do you understand that as you appear before the court today, you have the constitutional right to have a jury trial in this case?
Yes, ma'am.
Did you go over each of the rights that you would have if you decided to go to trial with your attorney?
Yes, ma'am.
And do you understand that if I accept your plea today, you're going to give up your right to go to trial?
Yes, ma'am.
Has anyone promised you anything or threatened you in any way in order to get you to plead guilty?
No, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
Do you understand that if I accept your plea today, if you change your mind at a later date and want to appeal your plea, the only way you'll get to do that is if you're granted permission to appeal from the circuit court?
Yes, ma'am.
Do you also understand that upon entering a guilty plea today, you could give up certain rights or issues on an appeal that you would have otherwise had if you went to trial?
Yes, ma'am.
Knowing all of this, is it still your decision to proceed with the plea today?
Yes, ma'am.
All right, so let's take your attention back to the date of the offense, May 9th of 2024. On that date, do you recall being in the city of Troy, Michigan?
Yes, ma'am.
So let's see, it is alleged here. Where were you?
He was at the Red Roof Inn parking lot.
Okay, so you're in the Red Roof Inn parking lot in the city of Troy, sir, on that day, is that true?
Yes, ma'am.
And it's alleged that you were there with a person by the name of Deja Pullen.
Yes, ma'am.
And who is that person to you?
That was an ex-girl.
Okay, and what happened on that day at the Red Roof Inn parking lot with Deja Pullen that makes you think you're guilty of the offense of domestic violence?
Did you punch her, sir, or hit her?
Yes, ma'am.
Okay,
And did you have, I'm sorry, did you have permission to hit her?
No, ma'am.
okay.
Thank you.
How do you plead to this allegation, sir? Do you plead guilty or not guilty?
I'm pleading guilty.
All right, are the attorneys satisfied with the taking of the plea?
People are satisfied, Your Honor.
Yes, Your Honor, I am satisfied as well.
All right, I am satisfied as well. I will accept your plea at this time. This is a case that we have to send for a review and a screening in the probation department. They'll have an obligation to try to contact the victim in this case, and then the prosecutor also has an obligation to contact the victim and let her know when the sentencing date will be in case she chooses to make a statement or submit something to the court for consideration. I know that you were just here last week. We talked a little bit about bond. At that point, you believed that you may be able to post bond. We had some concerns because there were some other outstanding bench warrants, but I don't think you were convinced that they were going to impact your ability to post bond. But if you remain in custody, we'll expedite, or I'll try to get you back here for sentencing as quickly as possible. That would be the plan.
Did the attorney make a bond motion last week?
We did talk about it, so it was a little bit unusual in that he had just been arraigned the day before he appeared last week on the 10th. But because it appeared he could remain in custody, the clerk's office really tries to get them on the docket as quickly as possible. So they put it on the very next day. This didn't provide a ton of notice to the prosecutor to get discovery to the attorney, Spencer Bondi, who was here on that day. And your client, rightfully so, wanted an opportunity to review that. So we just adjourned it out 1 week. There was some indication that I received that he wasn't in compliance with the bond that was set for drug and alcohol testing, but it was somewhat just dismissed because he was still in custody. And we did tell him that if he was able to post the bond, that he had to immediately contact both the Novi District Court and our court to ensure that he was compliant with any and all conditions.
I would ask the court for consideration to be heard on a bond motion.
Okay, what would you like to say?
Your Honor, he does have a job waiting for him at General Motors. He does have strong family support. His mother was present. I did speak with her. Unfortunately, she had an 11 o'clock Zoom hearing with her company CEO, so she had to leave. She really wanted to be here, and I wanted you to know that she was here most of the morning.
Okay, I saw her.
Yeah, and so with the job pending, he did take ownership of this case. He did take care of the ownership of the other case. But is it Novi or East Point where the other domestic violence occurred? So he is taking ownership of the issues. I think he'll be a good candidate for probation. Based on all that information, I am asking for consideration for reduction.
What are the people placing on the record, if anything?
Your Honor, the people would object to any sort of bond reduction at this time. The defendant was sentenced on a domestic violence out of the Novi court and was serving a sentence with the same victim as in this case. And due to the assaultive nature of this matter, the people would object to any sort of bond modification, Judge.
So I have the benefit of having all of the information that the magistrate likely considered at the time that the bond was set. It was determined at that time that pretrial services could not recommend a release on the defendant's recognizance because he met the requirements outlined in the Code of Criminal Procedure 765.6A, which requires the court to set a financial bail. I don't want to misrepresent something on the record. Okay, so he was on probation, as far as I can tell, for a similar offense involving the same victim. I don't think that there was an indication that he had violated the terms and conditions of his probation, but this warrant was hanging out there and had not yet been addressed when he came into contact with a police officer on a traffic stop. Does that sound right, sir? Is that what happened? So there's no allegation that you have a probation violation in Novi, or is there?
No, I don't.
Okay, so it was just you had contact with the police officer with the traffic stop, and then they recognized that you had this outstanding warrant.
Yes, ma'am.
Okay. I think there's some confusion as to whether or not there was a violation. But if there was a violation, it might have just been related to testing out of Novi, not a violation of the no contact provision. The bond is currently set in accordance with that Code of Criminal Procedure that the court just cited. And it's a $5,000 cash surety 10% bond. Because of the way that it's outlined in that code, he's not eligible for a personal recognizance fund.
No, I wasn't asking for personal. I'm sorry to clarify. I was asking for a reduction, perhaps to 2,500 cash surety 10%. Should be more clear.
So what has changed since the last court appearance in which your client indicated that he was going to be able to post the bond?
Judge, I apologize. I was not the attorney here last week. I just know, and I've spoken to my client twice today, and the information I provided about the job waiting at GM, I did speak to his mother. She was here, as the court indicated. That tells me he's got strong ties to the community. I don't think he's a flight risk. He did plead to both cases, so he is taking ownership of the issue.
Your Honor, just for the record, I do see a hold out of East Point for
We've talked about that one too. I have no way of verifying. That one was represented to be in place for a while. And that he's had contact with the criminal justice system since that time and didn't address it, but I don't know, sir, at what point you last had contact, because this one appears to have had a court date a couple of months ago that you missed.
I was across already.
Right, I know, but I still think the issue is going to be because you missed the court date, they put a bench warrant in place. And so I'm not sure that you would be permitted to be released, even with a reduction of bond, without addressing it. It's a $20,000 cash surety or 10% bond.
I'm trying to like address that like.
Okay,
ASAP.
sir,
I'm
don't
sorry.
talk
I'm
about the
sorry.
facts of the
Oh,
case,
oh,
because
okay.
anything you say in this record can't be used against you for that court.
Are you meaning though that you're trying to address it in terms of getting a court date there? Is that what you're trying to say?
He also has indicated to me a legal defense to that charge. It's not relevant for this case, but he does have a legal defense.
I think quite frankly, sir, I need more information about you. I can see that there are some steps you're trying to take to clear up outstanding warrants. But the other component in determining whether or not the bond is appropriate is a public safety concern. And in light of the fact that this offense that you just accepted responsibility for has the same victim as another offense that you're reporting to the novi court for, I really think it's appropriate that I complete a screening through probation, get information, verify what's actually outstanding in terms of criminal history that you have to address. And then I can make an informed decision about your sentence that is not going to change because I'll have all of that information in front of me. So you can still post the bond that was set. I'm not increasing it. It's going to stay exactly the same with the same conditions. But for me to reduce the bond, I would need to find a pretty significant reason to do that. And I still think those same issues of failing to appear history and concern for public safety, specifically the victim in this case, I haven't been able to get any more information that would support a decision to change the bond right now. So if I see that you are still going to continue at the Oakland County Jail, I'm asking the probation department, as they always do, to set a screening very quickly for you that likely will be conducted while you're at the jail. And then we'll set a sentencing date so I can bring you back and sentence you with all of the information that I have. You'll continue to get any credit that would be available to you. And you can continue to try to reach out to East Point to see if there's a way to resolve that bench warrant so it does not hold you up from being released when the time is right. Okay, thank you, sir.
Be safe, be well, sleep sweet, and much love.